Dear friends, good morning. No doubt there are so many directions by the Honorable Supreme Court of India to register FIR in cognizable cases. But still, this is not happening at the field level, and the people aggrieved party goes to the Supreme Court and again directions are issued. So, in a lately decided case, the judgment was delivered on 8th August 2023, in which the Honorable Supreme Court of India again gave some important directions, which I am going to discuss with you in this case. The criminal appeal is of 2023. This is Sindhu Jank versus State of Maharashtra, which was decided on 8/8/2023. No doubt there is earlier judgment of the same court, Supreme Court, in wait a little, in Lalta Kumari versus State of Uttar Pradesh, wherein registration of FIR was held to be mandatory under Section 154 of the CRPC. Then again the case came before the Honorable Supreme Court, and the Honorable Court gave few of the directions in which it said that registration of FIR is mandatory under Section 154 of the Code if the information discloses commission of cognizable offense and no preliminary inquiry is permissible in such a situation. Second direction was, if the information received does not disclose a cognizable offense, what indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. Third direction was, if the inquiry discloses the commission of a cognizable offense, the FIR must be registered in cases where preliminary inquiry ends in closing the complaint. A copy of the entry of such closure must be supplied to the first informant forthwith and not later than 1 week. Within 1 week, the concerned police station has to supply the report that we are closing the case. It must disclose reasons in brief for closing the complaint and not proceeding further. Fourth direction, which is given in this judgment, is the police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Action must be taken against erring officers who do not register the FIR if information received by him discloses a cognizable offense. And fifth direction in this judgment is, the scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense. Sixth direction in the judgment is as to what type and in which cases preliminary inquiry is to be conducted. Will depend on the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are matrimonial disputes, family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is abnormal delay in initiating criminal prosecution. For example, more than over 3 months delay in reporting the matter without satisfactorily explaining the reason for delay. The aforesaid are only illustrations and not exhaustive of all conditions which may warrant preliminary inquiry. Seventh direction was, while ensuring and protecting the rights of the accused as well as the complainant, a preliminary inquiry should be made time bound, and in any case it should not exceed 7 days. The fact of such delay and causes of it must be reflected in the journal diary entry. Eighth direction was, since the journal diary, station diary, daily diary is the record of all information received in a police station, the Honorable Court directed that all information relating to cognizable offences, whether resulting in registration of FIR or leading to an inquiry, must be mandatorily and meticulously reflected in the said diary, and decision to conduct a preliminary inquiry must also be reflected in the instant judgment. The above said directions were given so that the police stations are obliging the victim as per law and not harassing him so that he has to come again and again to these courts. Generally, what is seen that the police stations are reluctant to register FIR in spite of the 420 with the person. They say that this is civil case, you go to court for civil dispute. Actually, the cognizable offense has been happened in that case where he has been looted lakh of rupees and still the police is not obliging. So these directions are fixing the responsibility of the police officers and asking them to behave as per settled law of the country. Otherwise, you will have to face consequences. That's all in this little bit video. If you like, please subscribe to my channel so that I may make more and more videos on this concept of police force working in an improper manner. That's all.